Contracts are promises that courts will enforce. So when are contracts formed such that courts will enforce those agreements? This video is designed for law students who have finished their study of contract formation and are looking for a review of the material. We're going to use the Restatement of Contracts second to pull out some of the key rules involved in contract formation. Essentially, contract formation requires three things: an offer, which creates a power of acceptance, and consideration. We'll look at all three of these in turn, starting with offer. An offer is the manifestation of willingness to enter into a bargain, so made as to justify another person in understanding that his assent to the bargain is invited and will conclude it. So what's a manifestation? A manifestation is some kind of outward action, not a privately held belief or an opinion, but something that's actually said or done. In fact, contract law evaluates manifestations based on how an objective observer, not the person who actually witnesses the manifestation, but how a reasonable person in the position of that observer would understand the manifestation. So our broad definition of an offer is when the manifestation is made in action or words that a person who witnessed that and was in the position of receiving that purported offer would be reasonably justified in thinking that they could accept that offer. This is to be contrasted with mere preliminary negotiations. I'll use the example of selling you my car through this and twist that hypothetical a little bit to make different offers and purported offers. So one thing that's clearly an offer is if I say to you, I will sell you my car for $5,000 if you pay me cash on Friday. What if instead I said something more equivocal, like, what do you think about buying my car for $5,000? Or, make me an offer on my car. These are preliminary negotiations. They're not an unequivocal manifestation that would justify your assent. In fact, in the second case where I'd say, make me an offer on my car, we'll learn that we're missing a price term, and so we would fail for want of certainty. As the offeror, I control the bargain, and I can specify how you accept it. And one way to specify that is allowing you to accept only by performance. In my car example, I might say, if you want to accept this offer, I need the cash in my hand no later than 5 p.m. on Friday. A promise is not going to suffice. I've made it clear that the only way to accept this offer is by actually performing, by paying me the cash. But a more common example of when we have a unilateral contract would be a prize or a reward. The famous example in case law is the Carbolic Smoke Ball. A company sent out an advertisement that if you use the Carbolic Smoke Ball for a month and get the flu, they'll pay you $1,000. The only way to get the $1,000 was by actually taking the Carbolic Smoke Ball and getting the flu. A promise wouldn't suffice. But don't be misled. Offers generally can be accepted by promises or by performance. In other words, most offers are bilateral. We say bilateral because I make you a promise and you make me a promise. I promise to sell you my car and you promise to give me $5,000. Most offers are bilateral. It's unusual to have a unilateral offer, and mostly we see unilateral offers when it comes to prizes or fact patterns that law professors like to cook up. And finally, in order for there to be an offer, the terms have to be reasonably certain. Usually this means we have to have price, quantity, and the item in question, although there are some cases where price doesn't matter. But for the most part, in order to have a contract, we need to have those key terms. If we're lacking those terms, we might not have an offer, but be in preliminary negotiations. For example, I offer to sell you my car and ask you how much you think it's worth. Well, we know the item, the car, but we're missing the price term. So now we have two reasons why there's no offer. One is because asking you how much you think the car is worth seems to be a preliminary negotiation that will not justify that your assent is invited. And we have an uncertain term. What's the price? When terms are uncertain, the offer generally fails, not just because the terms are not certain enough to form an offer, but also because it makes it look more like preliminary negotiations. Once an offer has been made, the offeree now has the power of acceptance. The offeree needs the power of acceptance in order to accept an agreement. Power of acceptance does not last forever, however. It can be terminated by rejection, counteroffer, lapse of time, revocation of the offer, or death or incapacity. A rejection of the offer will terminate the power of acceptance, and a counteroffer will function as a rejection. Let's take a closer look at these two important terms. Again, we need a manifestation here. So a rejection needs to be an outward display, either acts or words which objectively, reasonably manifest an intention not to accept the offer. There is an exception, however. If there is a manifestation to take the offer under further advisement, which comes more into play with regard to counteroffers. A counteroffer is when a manifestation makes a substitute bargain, which is a proposal for a bargain about the same matter but with different terms. For example, I say to you, I'd like to sell you my car for $5,000 if you will pay me $5,000 cash on Friday. And you reply, I accept your offer, but I'll pay you $5,000 cash on Saturday. We now have different terms. And so what you have said is in fact a counteroffer. You might have instead said, I'll think about your offer, but would you take $3,000 today? Again, here we have a proposal on the same matter with different terms. I offered to sell the car for $5,000 and you offered to buy it for $3,000. So we have a difference on the price term. But when you said, I'll think about it, that was a manifestation of your intention to take the original offer under further advisement. And so it would not terminate the offer. But when there has been a rejection or a counteroffer that does not manifest an intention to take under further advisement, this terminates the power of acceptance when that manifestation is received by the offeror. A lapse of time can also terminate the power of acceptance. Sometimes the amount of time permitted to respond is specified in the offer, like, I'll give you a week to get back to me. But many offers don't specify that, in which case the courts will infer there is a reasonable time. How long is a reasonable time? This is inherently a question of fact that depends on all the circumstances. For something where the price changes quickly, like stock or maybe real estate, the time that a court will inform is shorter than something where the price is more stable. A revocation is the flip side of a rejection. Remember that a rejection is when the offeree declines the offer. A revocation is when the offeror pulls back the offer. There are two ways that a revocation can be manifest. A direct revocation is a manifestation in actions or in words from the offeror to the offeree of the intent not to contract. For example, on Monday I say to you, I will sell you my car for $5,000. And on $2,000 I say, I'm not interested in selling you my car anymore. That's all it takes to have a direct revocation. But we might also have an indirect revocation, which is when the offeror takes an action that's inconsistent with keeping to the contract. For example, on Monday I offer to sell you my car, and on Tuesday you learn I've sold it to somebody else. I haven't made any manifestation directly to you, but once you've learned that I've sold the car to somebody else, it's no longer reasonable for you to think the offer is still open to you. We say that revocation terminates the power of acceptance when it is received by the offeree. There are a few special rules regarding option contracts. An option contract, as we'll learn in a few slides, is a special kind of contract that makes offers irrevocable. General offers, or public advertisements, are advertisements or statements made toward the general public, and they can only be revoked by a notification given in the same way. Now, most advertisements aren't offers for reasons we discussed on the offer slide, but when they are, they need to be revoked in the same medium or with a wider distribution than how they are originally made. Death or incapacity also terminates the power of acceptance. It doesn't matter whether the offeror or the offeree died. Either way, the power of acceptance is terminated when the offeror or the offeree dies or becomes legally incapacitated. Again, this doesn't affect option contracts. The option contract is a valid and binding contract which prevents death from terminating the power of acceptance. We also need to find acceptance in all of our agreements, and an acceptance is likewise a manifestation, an outward sign, not privately held thoughts. A manifestation can either be by a promise. For example, I say to you, I will sell you my car for $5,000, and you say, I accept. But it can also be by performance. We know that there are two general kinds of offers, those for unilateral contracts and those for bilateral contracts. An offer for a unilateral contract can only be accepted by fully performing. But an offer for a bilateral contract can be accepted by partly performing. This is how that would work. I say to you, I would like to sell you my car for $5,000. And while you don't speak, you reach into your wallet and you pull out 5 $100 bills and hand them to me. You have just performed at least part of what the offer requested, namely tendering $5,000 by tendering $500. And this manifestation might reasonably be interpreted as your intention to be bound by this promise, meaning to conclude it by paying the other $4,500. In order to accept an offer, you have to have knowledge of the offer. This comes up in two ways. Most notably, this comes up when a person begins performance under a unilateral contract offer without knowledge. A common example is a person goes to a bar and starts to play a trivia game without realizing that there is a $1,000 prize for the person who gets the most questions right. This is a unilateral contract offer. In order to get the $1,000, you have to perform, and the performance is to score the highest on the trivia contest. It's no good to promise you're going to score the highest. You need to actually get the highest score, or complete performance. So you begin earning points. You answer question 1 correct, and question 2 correct, and question 3 correct, all the time only having fun in this 5-question trivia contest. You might even answer question 4 correct without any knowledge that you're playing for keeps or playing for money. All you need is knowledge that there is a prize before you answer that 5th question correctly and win, in order to have knowledge that is sufficient to accept this offer by performing completely under the unilateral contract. If you've accepted by performance, notice may be necessary. Generally, notice is not necessary when accepting by a promise, because the promise itself made to the offeror constitutes notice of your acceptance. But if you're accepting a bilateral contract by performing, it may be necessary to notify the offeror. For example, let's say I offer to pay you $1,000 to lay 100 bricks in my driveway. Without saying anything, you show up the next day while I'm at work and you lay the first brick. I may not be aware that you have done so, in which case it would be necessary for you to actually tell me that you have done so in order to constitute acceptance. If the offeree has reason to know that the offeror has no means of learning of the performance with reasonable promptness and certainty, the offeree needs to notify the offeror diligently. In determining whether there is an offer, we want to determine the difference between an acceptance and a counteroffer, which can sometimes masquerade as an acceptance. A purported offer which adds qualifications that are essential, meaning the acceptance is conditioned on the offeror's assent to these new terms, this is a counteroffer because the terms are additional to or different than what was stated in the original offer. However, one term changes a little more easily without killing the offer and acceptance process. Sometimes an offeror will suggest a time, place, or manner of acceptance. If it's merely a suggestion, but not a requirement, another method of acceptance is not precluded. The restatement offers a quaint example. In illustration 2, A makes an offer to B and adds, "Send your office boy around with an answer to this by 12 o'clock. The offeree himself comes before 12 and accepts. There is a contract. While the offer suggested the offeree sent his office boy around before 12, having the actual offeree come before 12 o'clock also sufficed as a manner of acceptance." Contrasted more directly with Section 59 is Section 61, an acceptance which requests a change of terms. Request is the key word here. Let's say I offer to sell you my car for $5,000 provided that you pay me on Friday. You might reply, "I accept your offer, but I will pay you on Saturday." If you do this, you've changed the terms and you don't have a valid acceptance. Instead, you've made a counteroffer that I can either accept or reject. Alternatively, you might say to me, "I accept your offer, but would it be possible to pay you on Saturday instead? I'd really prefer it." Now we have a binding contract and you have to pay me on Friday, but it's up to me whether or not to permit this change of terms. While most acceptances are by words and some by deeds, it's possible for acceptance by silence to occur. But it only occurs in 3 cases. When the offeree takes the benefit of the offered services, even though that offeree had a reasonable opportunity to reject them and knew they were offered with the expectation of a remuneration. When the offeror has stated previously that assent may be manifested by silence or inaction, and the offeree actually intends to go by this prior statement and remain silent in order to accept. Or, because of previous dealings, it is reasonable for the offeree to think that a lack of notice will constitute an acceptance. The third element to contract formation is consideration. Consideration is a difficult term to nail down, and its meaning has changed over the times. But the modern restatement version discusses it as a bargain for exchange. To constitute consideration, a promise or return promise must be bargained for. This is contrasted with a conditional promise, which is something one needs to do in order to receive a gift, but is not consideration for a bargain. A classic example of a conditional promise is when a wealthy man sees a tramp on the side of the road and says to the tramp, "If you go to that clothing store on the corner, I'll buy you a new coat." You might think that going to the store is consideration for this promise, but it's better understood as a condition to receive a gift. Another old rule we should dust off is the adequacy requirement. There is no additional requirement of benefit or detriment, and no requirement for the consideration to have the same value as the promise. Courts are not in the position of deciding what are the value of promises, so long as the consideration is worth something, not entirely worthless. It'll be considered adequate consideration. The key thing is that that consideration is actually a motive or inducing cause. When I say an inducing cause, I mean it's a reason why the parties entered into the bargain. The promisee wanted to receive the consideration and gave the promise in return for it. Meanwhile, the promisor wanted the promise and gave the consideration in return for it. This concept of mutual inducement and bargain for exchange is at the heart of the modern consideration doctrine. But even when this doctrine is not met, we sometimes enforce contracts anyway based on a theory of detrimental reliance or promissory estoppel. When the promise would reasonably induce action or forbearance on the promisee, and does in fact induce such action or forbearance, courts might hold the contract binding even for one of consideration. Let's take a deeper look at the bargain for concept. Courts will often talk about this as a quid pro quo, which is Latin for this for that. It's the idea of reciprocal motivation. I enter into the bargain to receive the consideration. and I offer the consideration in return for your promise. In order for it to be bargained for, it needs to induce entering into the contract, but it doesn't have to be the only reason. For example, A offers to buy a book owned by B and pay B $10 in exchange therefor. B's transfer and delivery of the book are consideration for A's promise, even though both parties know that the book is really worth $5, and part of A's motive in making the offer is to make a gift to B of $5. Even though $10 is the amount given for the $5 book, and part of the reason for this transaction is to give a $5 gift, the other $5 was induced by the receipt of the book, and therefore the contract is enforceable. The Promissory Estoppel doctrine holds that when a promise can be reasonably expected to induce reliance and actually so induces, and when injustice can be avoided only by enforcement of this promise, then courts will grant limited remedies, even though there was not consideration. Option contracts are special kinds of contracts that limit the promissor's power to revoke an offer. Critically, option contracts are contracts, so they need to meet the requirements of a contract. That means they need offer, acceptance, and consideration, unless there's some statutory or common law reason otherwise. When there's an option contract, the power of acceptance is not terminated by revocation by the offeror or death of the offeror. I actually break with the restatement regarding rejection and counteroffer in option contracts. The restatement plainly says that a rejection or counteroffer does not terminate an offer under an option contract. But more recent scholarship has shown that in general, courts do find that rejection or counteroffer terminates an offer even when there is an option contract. One way you can form an option contract is by partly performing an offer for a unilateral contract. This is to avoid injustice. For example, I offer to pay $10,000 to the first person who climbs to the top of Mount Everest. I'm doing this as a publicity stunt to get attention for my business. Several people start up the mountain, and right before the first person reaches that peak, I say, I revoke the offer. Now, without any additional rules, I would not be bound to pay that person $10,000 when they reach the top. But this is an unfair result because that person would not undertake that except for wanting to receive the $10,000. And there's no way to accept that offer without completing performance. So we have a rule in Section 45 that beginning performance of a unilateral contract forms an option contract, giving the person a reasonable time to complete it. Mailbox rules deal with when different elements of a contract are effective. A rejection or counteroffer terminates the power of acceptance when it is received. What does received mean? Receipt means deposited in a place which has been authorized. Your mailbox, for example, is a place where you're authorized to receive notifications. An acceptance is effective when sent. What does sent mean? Sent means put out of the offeror's possession, like when you give the letter to the mailman. This is only the case if the letter was properly dispatched. An acceptance is not effective if it has the wrong address on it. In conclusion, contracts require three things: offer, acceptance, and consideration. These are legal requirements, and we look at whether an objectively reasonable person would find that a manifestation constitutes such things. But even when a contract was actually formed, there are defenses in law and in equity, which we'll discuss in another lecture, that can prevent that contract from being enforceable. I'm Professor Seth C. Orenberg. Thanks for watching.